Good afternoon, everyone. I hope you're all doing well on this dreary Monday afternoon. For those of you who don't know me, my name is Ron, and I am a peer program coordinator for Spinal Cord Injury Ontario. I would like to introduce you to my co-host, Lubna. She is the manager of the peer program. Thank you all for joining us today. I would like to begin by acknowledging that we live and work on the traditional territories of many Indigenous nations across Turtle Island. While we meet today on a virtual platform, we must recognize the importance of the land and the treaty agreements we acknowledge with the ancestral and unceded territories of the Inuit, Métis, and First Nations people. As Spinal Cord Injury Ontario community encompasses many geographies, we ask that everyone take a few moments of their day to find out which unceded or treaty territories you may live and work on. You can use the link www.native-land. Oops. What happened here? .land or .ca to learn more. There are a few rules of engagement I would like to quickly go through before we begin. Participants will be muted upon entry, as this will cut down on the background noise during our presentation. We will maintain the mute feature throughout the session. If you do not wish to be seen, please ensure your video is turned off. You will be able to see and hear the meeting, even if your video and audio are not on. You can simply change your name that appears on the screen should you wish your full name not to be shown. Simply put your cursor over your name, right-click, scroll down, and click on Rename. You can put your first name, initials, or anything you want. There will be a Q&A session throughout the presentation. If you have any questions, we welcome you to use the raised hand option, which is located by clicking on the reaction button at the bottom of the screen. When prompted, unmute yourself and ask a question. Type your question in the chat feature located at the bottom of the screen as well. Now that we've got that out of the way, I would like to turn it over to our guest presentators from Hudson Wealth and Trust Planning Group and Disability Finance Specialist.
Thanks, Ron. Good afternoon, everybody. My name is Daniel Carroll. I'm standing in for my partner today, Percy Pierre, who was scheduled to give this presentation, but unfortunately has some health issues he's dealing with, so he wasn't able to make it. Typically, we do this kind of jointly, but this is his area of specialty. He is our in-house trust expert, and with, of course, trust planning is a key component of estate planning, so he does do a lot of things like that. That said, I'm not unskilled at this area of finance. I am a financial planner, and I do work in this area. So I'm going to share the screen now, but I guess all that to say, please bear with me. This is not my presentation. This is Percy, so I may be a little bit choppy as we go through, but I'll do my best. And feel free to ask questions, as Ron said, in the chat. Maybe Lubna, if you see one come up that's worth addressing, Lubna, sorry, worth addressing at the time, please feel free to interrupt me. I'm happy to address questions as they come. So with that, I am going to try to test my prowess in sharing my screen. This should be the one to share. There we go. Okay, and I'll just move this over here so I can see what I'm doing. Oops, there we go. Okay, so as Ron mentioned, my company is Hudson Wealth and Trust Planning Group. We are a full-scale financial planning company that specializes in working with people with disability and their families. We have a long history of working with survivors of motor vehicle accidents and medical malpractice and these sorts of things. So we are well-versed in the areas of government benefits and all of those things. And our approach to financial planning is is unique in that we have a sort of deeper understanding of the needs of persons living with disability. And there are a number of government programs and benefits and charitable programs and benefits out there that sort of don't factor into the standard realm of financial planning, which is why we developed this specialty, because each one of the partners, and actually now several of our associates as well who've come to us, have come to us because they've had personal struggles with personal injury, and they've sought answers and not been able to find them until they found us. And then of course, if they're financial professionals, they've sought to join our group. So that's where Hudson was born, was out of that need. Percy, as I mentioned, is our co-founding and managing partner. Normally, he would be giving this presentation because he is a member of the Trust and Estate Planning Group of Mississauga. He has a long history, 30 years in the business, but has always sort of, certainly in the last little while, or the latter decade of his career, has focused a lot on estate planning and trusts. So there's a good expertise there. He did create this presentation, so again, bear with me as I do my best to go through what we're talking about. But the general focus here is going to be on, what out of the gate, what is estate planning, and ultimately what we're trying to do with estate planning is to find a way to transfer wealth or transfer assets efficiently from one generation to the next. And when it comes to working with somebody who has dependencies on government benefits and things like that, this is an area of financial planning that gets very complicated. It's a very complicated area regardless. It's extra complicated when we're dealing with a disabled child or a disabled family member. So one of the things, or some of the things that we have to really focus on here, is to ensure that the child or adult will receive the kind of support and care that's required. And of course, everybody sitting in on this today knows that there are additional costs associated with managing life with a spinal cord injury. So we want to sort of address some of the areas that are extremely important in this area, to ensure that the financial means are available for a disabled child or loved one. And of course, preserving government benefits is often at the forefront. We want to make sure that everybody continues to receive whatever government benefits they're entitled to, and that may be from the monetary perspective, such as ODSP's living support or rent support, but also the medical dental coverage that comes with these programs. Now, anybody who's been following the news in the last little bit with the latest budget that came out from the federal government, we are going to see the introduction of a national dental care program, which will be excellent for a lot of people who have been very heavily dependent on the ODSP plan to handle their dental needs. What this does is it actually frees up a lot of people who were so dependent on the drug and dental that they can now get their drug costs covered perhaps by the Trillium program, which is less restrictive than the ODSP program on the monetary side of things, on the money, because ODSP has a lot of rules around how people can receive money by way of an estate or how much money they can earn. So we'll get into that in a little bit. And we're going to take a look at a hypothetical case here where we look at a family, and it's from the perspective of John and Mary Smith. Don't blame me, I didn't come up with the names. Obviously, Percy's just going straight down simple lane there. John and Mary Smith have a disabled child. Ethan has a spinal cord injury. Prior to his injury, he had a child, so there's a grandchild. Ethan has a brother, his brother's Joseph, and both John and Mary also have siblings as well. So we're going to look at how this comes into play. And we're talking about 4 generations here. So it's very important that there are a lot of considerations. This means there's a lot of moving parts. And of course, everybody in this family wants to make sure that they do the best they can for everybody, but particularly for Ethan because of his disability. All right. So some of the issues here that are that float up to become the important things that need to be addressed: who will provide care, because great care must be taken to select a caregiver for an adult child after the person's death, in this case John and Mary Smith, and usually this is a close member, family member, such as a sibling. And what we always do in this area is to recommend that a family consider that there be more than one person to provide that continuity of support. So if it's possible, we want to bring in more than one family member, because you want to have a contingency plan, a backup plan, and you want to have someone who can share the work, particularly when we're talking about finance and care, because it can become task heavy. And we want to make sure that nobody gets burnt out by the amount of effort that has to be put in. So we take a deep look at that and see how that can be done. And in the absence of a family member in that area, then of course we look to professional services where possible. So this person, though, if we are able to bring a family member in, should be highly involved in the disabled person's life, should be very much concerned about their health and welfare going forward, be sensitive to their needs and wants, and understand the terms of the will and any trusts. And we'll get into that a little bit more deeply later about what happens in this area, because we do see a lot in clients that come to our firm with their wills already done. There's a lot of ambiguity, and that can create problems. It's not clear what the intention is or the intentions are. And that doesn't necessarily mean from just the monetary perspective. It may be clear that the money is supposed to go here and here and here, but to be used in what way? And that's frequently an area that gets sort of left out of a will, because a will is sort of, there are rules to making a will and it's governed by the law. And a lot of times the lawyers go down that road without another document, which is called a letter of wishes, which sort of clearly dictates what the testator, and that's the term we give to the person who died or the person who's created the will, the person who's bequeathing the assets, what the testator wants done with the money. So again, we'll get into that in a little bit more detail in a minute. This person who's providing care should also understand how to invest the money for the benefit of a child or a person with a disability. And will, of course, be very careful with any monies that they're responsible for. And that's a key consideration. And we want to make sure that that person has good judgment and is, again, very focused on the well-being of the person with the disability, so that they may, where needed, seek professional assistance or seek help and advice from somebody who might be able to help in areas where they aren't entirely sure of what should be done and how. So note that legal custody cannot be assumed, and even when documented in a will, it still requires court approval. That's for the case of a minor child. So subsequent guardianship may be an issue to be concerned about, and a court-appointed guardian can be applied for and must be applied for in cases when dealing with a minor. So depending on the financial circumstances of the client, a specific bequest may be included in the will or a generous share of the estate residue. And that's a term given to once things are sort of divvied up per the wishes, whatever is left over is to be done or managed in a specific way. That leftover component of an estate is called the residue, or the residual amount, or residual distribution. We want to make sure that there is good insurance in place, if possible, for any would-be caregivers or any trustees, if they're family members, these sorts of things, because again, if something happens to that person, there may be financial costs to replace them. So these are key considerations. And on the death of the testator, there will be an income tax assessment and possibly capital gains and estate taxes on the assets and things like this. So proper pre-testamentary planning may be very important, or is very important, for reducing taxes. And it's one of the areas where we see the greatest mistakes get made is in the area of not managing the tax component of the estate planning. The other area that we see not done well is the strategy to be used to preserve government benefits. And some people may have heard of a Henson Trust as being a good vehicle, but there are ways where that Henson Trust may be done incorrectly. And I can tell you from experience that there are not a lot of lawyers out there who know all of the fine print details of creating a Henson Trust. Again, a topic we'll examine a little bit more in a little bit more detail shortly. So let's go back to John and Mary Smith. They have their disabled child. Considerations here that the parents or the grandparents or other parties must be cautious when planning to make bequests to the disabled child, and that government benefits that that child is receiving may be compromised if that inheritance is not managed properly. When we talk about ODSP, they have a set of rules and regulations that limit what a person can have. And that is they're allowed to make up to $10,000 for any 12-month period. Any income earned over that $10,000 amount may be subject to a clawback. But what they do is ODSP does not claw back dollar for dollar. So if a person is working and they exceed the $10,000 mark, ODSP usually will adjudicate and say that maybe it's 50%. So what they'll do is they'll reduce the entitlement going forward by sort of 50 cents to the dollar for every dollar over 10,000 earned. And that's fine for a lot of people because you're replacing the income you would have gotten from them, but it again allows you to keep that medical dental plan intact. With ODSP, they do allow exemptions. Personal injury awards are exempt to the extent that they don't include any component for future loss of income. Primary residence is exempt from a calculation of assets. One vehicle is exempt. And then trust funds and insurance policies up to a combined value of $100,000. And that unfortunately does include the growth. When those are placed into an informal trust, you can use that $100,000 limit as an exemption. Investments or assets can be up to $40,000, and then any amount that's held in an RDSP. So one of the areas that we examine frequently when we are looking to build an estate plan for a person with a disability or for a family member of a person with a disability is how much room is left in the RDSP? Is an RDSP open? And what is the best way to do it? This provides two advantages. Number one, we can roll over our RSPs. So John and Mary Smith want to leave money to their child, Ethan. They can roll some of the balance of their RRSP into an RDSP and do so tax-free, which is fantastic because it reduces the amount of tax that the estate will pay, and it helps preserve ODSP, and it allows a significant amount of assets to be transferred to the disabled child, in this case, Ethan. So lots of considerations to examine here in great care. So one of the options here when we're talking about this, as I touched on, is a trust. And this is an area where I really wish I had Percy to speak to it, because some of the language around the trust, although it can be highly technical and maybe it's not entirely relevant for today. So I apologize if somebody is here to hear more about the trust. If that's your area of interest, then we can book time to discuss it further, or you can book with Percy. He'd be happy to go through this with you as well. But I will touch on it to some extent here today. So we're talking about coordinating between parents and grandparents or any other parties that are involved, because the wills have to be set up sort of in sequence to say that the first person to pass on will create the trust, and then the next generation or the next people in the family who move to the great beyond will use their wills, will fund an existing trust. And we want that to be either a qualified disability trust or regulation trust. Again, there are tons of different trust technicalities. Which one is the right trust, again, is something that would be examined on a case-by-case basis. And again, when ODSP is a consideration, then we want to make sure that these trusts are managed properly. All right. And a trust can be created by a will, which is a testamentary trust, or it can be created while the person is living, which is an inter vivos trust. So how that happens, and this happens, we see this fairly frequently, is that some people will set up an inter vivos trust and begin funding it while they're alive. And that trust will be for the beneficiary, the benefit of the disabled child. So if that child qualifies for the disability tax credit, that disability trust may be what's referred to as a QDT, or qualified disability trust. These trusts have preferred tax rules. So it allows the trust to pay less tax over time. Same with a Henson trust. Henson trust is a very specific type of trust, which I'm going to get into on the next slide. So I won't go too far down that rabbit hole now. This type of trust, though, must be a testamentary trust, and a beneficiary can only have one. So if there are multiple family members who've set up multiple trusts, one trust can be declared the QDT. And that's why we often say that this coordinated approach across all family members is very important, because the last thing you want to do is have a whole bunch of different trusts set up. And if only one can be declared the QDT, then the other trust will pay tax at the highest marginal rate. And that's obviously not in the best interest of the person with a disability, because they would have less tax exposure if the money was in their hands directly. So again, key considerations: why is a trust being set up? Who is setting that trust up? And which one is going to have the preferred tax treatment? Or can money be funneled into one single trust, or perhaps two, depending on how it is? And there are family members with more than one disabled child out there. So all of that and how that works, again, requires a little bit of significant amount of planning at the outset. Okay, so as the last line here says, qualified disability trusts are taxed at the graduated tax rate, and that's for at the beneficiary's level.
We have a question, Daniel.
Yes.
Can the trust be made after the person dies if they didn't have a will?
No. So it's very tricky. When somebody dies, the law is fairly clear on this. People cannot redo what they wanted the will to look like. And that is a bit of a pitfall, again, in the area, which is why it's so important to do this prior to the testator passing on. But no, you cannot create a trust after someone has died and then fund it as if it had been done while they were living. So these are definitely areas of concern. Now, without going too far down on this question, there may be other things that can be done depending on what the goal is. If you're trying to preserve ODSP by creating a Henson trust after the person has died, that cannot be done, because ODSP has what's called a non-gifting provision. Now, I do believe that special motion could be brought before the court, although I have had this question come up before. I did refer the client to a lawyer that I use for Henson Trust, and the answer came back as no, it cannot be done.
They say that, what if there's no will? So if there's no will and a person passes away, are there any exemptions?
This is what's referred to as dying intestate. And intestate, the rules are fairly clear that the money goes to the closest relative or relatives, but it is a very, very tricky area. So if they died with no will, or the person died intestate, there really isn't a whole lot that can be done. There are a set of guidelines that are outlined by the courts that must be followed. Does that clear that up?
Yeah, I have not received a follow-up question, so this
okay.
is
The considerations here, and again, depending on what the goal is, if you're asking this question because you want to know if a trust can be created for the purposes of preserving ODSP, generally speaking, no. I've not seen a case where that has been allowed, again, because we're dealing with the rules of dying intestate. And the non-gifting provision. So technically, when a person dies, if the money comes to that disabled person because they're next in line as per the rules of the court on who gets what based on the relationship to the testator, then they cannot take that money and gift it to a trust, because as you see on the slide here, this Henson trust is an absolute discretionary trust, meaning the person who is the beneficiary of the trust has no legal entitlement to the money inside, which means they can't have that money and give it away to that trust, because a trust is a complete legal entity unto itself. So from the ODSP preservation strategy, that's not there. Now, what I can say is that ODSP can be reasonable from time to time. I know a lot of people just rolled their eyes because if anybody's dealt with ODSP, they're usually unreasonable, but sometimes they will be reasonable. And in the case of somebody dying intestate with sort of what we would deem to be an unintended windfall from an estate, you may be able to appeal to ODSP to say that, had I known, proper steps would have been taken. This person died. I don't want the negative effects to befall me because they didn't prepare their estate properly. So you can appeal to ODSP and they will rule on it. And it usually comes down to a calculation of needs. And I think in those cases, they tend to be a little bit more reasonable. Okay. So again, I made some assumptions there that this was the question was sort of pertaining to ODSP, but because otherwise there's less of a problem if you're just receiving money. You receive some money and you move on. But if that's the case, if not, again, we can have a more detailed discussion about the particulars at another time. So with this Henson Trust for ODSP, there is no limit what can be put in there, because again, as I said, it's an absolute discretionary trust, meaning it is a legal entity unto itself. The money that goes in there, the beneficiary of the trust had no legal entitlement to whatsoever. So this came out of a case for Audrey Henson. It's back in 1985. That's how the trust got its name. And it was a precedent-setting court case that ODSP was then forced to reinstate the benefits of the child because of the creation of this trust. And you'll see here the last line that the income from the trust may be exempt. So that's straight from the wording of ODSP. Again, I find ODSP likes to have back doors on all the rules, which makes my job rather difficult. But it should be, and to the best of my knowledge and our practices so far, it has been deemed exempt income from the trust. However, ODSP does have the rule that they may deem it to be non-exempt income. Okay, if the parents have registered investments like an RRSP or a RIF, these can now be rolled over. As I mentioned, they can be rolled over by a personal testamentary trust to a lifetime benefits trust. But the beneficiary must be financially dependent and cognitively impaired. So one of those rules, again, around taxation that you want to take care of or take advantage of in cases of cognitive impairment, this is a great way to go because, again, we're saving tax. So in cases where an RRSP or a RIF are larger than the limit in an RDSP, this is another option available. The LBT is primarily a tax planning tool, as I mentioned, so it defers the tax, meaning as the taxes or as the funds are withdrawn from the trust, the tax is then due. But again, it would be taxed at the graduated rate and in the hands of the beneficiary. It's also another trust that is exempt for ODSP purposes, but the income from this trust is not exempt. So again, this is a little bit more of the finer details. It can be a bit tricky to navigate these sorts of things. Ideally, the Henson Trust will provide the best benefit, but there are ways of dealing with things when it comes to ODSP. Oh, sorry, I should go back here. This trust must purchase a qualifying trust annuity. So the money comes over from a RIF, which is sort of like an annuity. It's going to be rolled into an annuity that must be paid out for life or until the beneficiary turns 90 years minus the age of when the annuity is purchased. So there are some rules again around this type of trust that require special care for navigating. So as I mentioned a little bit earlier, the registered disability savings plan is something that you want to set up for a child as soon as possible. You don't necessarily have to contribute to it right away, but it is something that you want to get set up. And there are strategies, again, to maximize the benefits of an RDSP, not the least of which is the $70,000 in grants. It does take 20 years of contributions to gather all of that up. And you'll see that the number coincidentally with the government bond also equals about 20 years. So having 20 years of contribution to an RDSP is ideal. It doesn't mean that, oh, well, I don't have 20 years, because the last date you're eligible for grants is a calendar year in which you turn 49, or the beneficiary turns 49. That's the last year the government will contribute, excuse me, grants and bonds. So if you don't have 20 years to age 49, meaning you don't start at 29, it doesn't mean it's too late. It just means that how you collect that grant and bond money may change. And you can reach back in time to gather. So if someone was injured 4, 5, 6 years ago and they didn't open an RDSP, you can make additional contributions in a year. I believe you're allowed to go back as far as 3 in 1 year. So you would contribute this year's amount plus 4,500 for 3 years past and capture 4 years worth of grants in 1 year. Bonds will be automatically updated based on your T1 filing. So when with the disability tax credit application, you apply and state the date of injury or the date of disability, and then you can check a box on that application form if you wish to have previous years tax filings updated so that you get those additional tax deductions, and also then that would trigger the additional bond money. The grant money you still have to contribute to capture, so you would have to sort of to catch it up, accelerate your contributions in the first year or two, depending on how many years of catch up you have. Okay, so obviously what we're talking about here is very important to come down to how you make your will or how a will is structured. This is a very important legal document, just like powers of attorney, which we'll talk about as well. And this is why, again, when we're talking about a family, everybody's will has to sort of speak the same language or work towards the same goal. So what is a will? It's a declaration of a person's wishes regarding the disposition of his or her assets after death. It can also be defined as a legal document by which a person, a testator or testatrix, names another person, an executor or an administrator of their estate, to manage and transfer his or her property and wealth with effect on death. So again, what we're talking about here is sort of legally defining what is to happen with your assets when you die. There are different types of wills. A holographic will is one that is handwritten and signed by the testator, and this does not require a witness. The idea is that your handwriting is your own. Everybody has sort of their own specific handwriting. So if you wrote out a will by hand, you cannot type it and sign it. It has to be written out by hand for this to qualify as a will. Although there's the conventional will, which is typed and usually constructed by a lawyer or a paralegal. It requires 2 witnesses. Those witnesses cannot be family members and they cannot be beneficiaries of the will of the assets. So these are important things to consider. In Quebec, you can have a notary as one witness, but I think we're all in Ontario here today, so I won't get into Quebec stuff or the international components as well. Again, there are some rules for people who are from other countries who have wills in those other countries and have assets in those other countries. Very specific stuff around that, but for the sake of moving along today, I won't go too far down that rabbit hole, but it is something that should be considered if that applies to your individual cases. You should always appoint as well a contingent executor. So if you name your brother or sister or uncle or cousin or child as the executor, you should consider having an additional family member or two family members. If you've made two family members executors, you should also appoint a lawyer or a firm to adjudicate, because sometimes what happens is that the executors don't agree with the interpretation of the will. And of course, in some cases, executors are also beneficiaries of the assets. So if they disagree, you need to have a third person who can break the tie or provide additional insight into the interpretation of a will. One of the fastest growing areas of law in Canada right now is estate litigation. So lots of brothers and sisters are suing each other, suing the estate, suing executors, and saying that that's not what dad told me he wanted. That's what I don't believe is in that will. I believe you've altered the will. These sorts of things are happening quite commonly, which is why we often recommend that if you create a will with a lawyer, then the lawyer keeps a copy of it, and you appoint that lawyer or his or her successors in their practice to be that adjudicating body on decision making between executors or interpretations of the will. So these are, again, this is an area that seems at first blush to be fairly simple. I write a will, I say what I want done with my money, but we've seen it, and increasingly so on the other side, it gets messy very quickly. I think I pretty well covered this slide ahead of time, so I will move on. Alternatives to a will. These are, obviously, we've talked about inter vivos trusts, but also inter vivos gifts. One of the growing areas that we see in the world of finance and are often recommending is that elderly people who are getting near the end of their life, who know that they're not going to outlive their wealth, should begin to gift some of it while they're alive, because gifts are free, they're tax-free, and it helps to sort of distribute some of the wealth prior to it going through their estate, which means it would then be exposed to tax. So inter vivos gifts are not a bad way to go. They're also private. And this is why, we've seen in a lot of cases that one of the areas where people can get messy is that because estates are on the public record, and if you've got somebody in the family who thinks that they should have gotten some money from your will, they can go and look it up. And that's where, again, it could lead to estate litigation. So you want to be careful in that area. And that's why inter vivos gifts are pretty good. But you've also got to be careful with inter vivos gifts, because we see people in the latter phases of life who are, maybe have some dementia or things like that. They can be very robust in gifting, and the people who are receiving those gifts are at risk of litigation for taking the gift if they know that the person is not of sound mind. So these are areas of concern. Also, we see that in some cases, maybe less than honest family members go and convince an uncle who's got dementia or Alzheimer's to change his will. And that's where we have to be very careful. Fortunately, in cases where you have the will with the lawyer's due diligence is to ensure that the person is of sound mind and body. That is one of the key elements of a will. So you also want to be careful in this area. So we've seen a lot of things where we see parents put their children on the real estate as joint tenant. This is an area to be very careful of, particularly if that child is married and if the marriage isn't sound and the parents are still alive. If that marriage dissolves or breaks up, the spouse who's leaving does have some entitlement to that property. So I'm always cautious when I hear people come to me with this suggestion, like, oh, my mom's going to put me on joint tenant, so that way the value of her house doesn't go through the estate, and it'll reduce the estate tax. It's a dangerous thing to do unless everyone is very confident that there isn't going to be any issues in any divorce proceedings. But technically, when that happens, and this is an area where people make this mistake, is when that happens, that's technically a deemed disposition. And then if that child also owns their own property, now we have the difficulty of which property is primary residence, and is then the second one going to be subject to capital gains. So this joint tenant idea that people frequently come to the table with as a great idea to avoid estate tax usually introduces a lot more risk and can then therefore introduce capital gains tax. So the whole procedure was for naught, because the capital gains tax will be more than the estate tax would have been. So that's something you've got to be very careful of, and keep in mind, CRA has already thought of a lot of this stuff. So don't try to outsmart the tax man, as they say. One of the things too, we want to be very careful with trusts, certainly when we're talking about a Henson trust. If you're going to use a Henson trust for the benefit or the preservation of ODSP, and you're creating this trust for a disabled child who has no children, then there has to be a gift over provision, meaning if the beneficiary, if the person who's the beneficiary of the trust, the person with the disability dies, what happens to the residue in that trust? That trust has to be declared to go to, or the assets in that have to be declared to go to somebody else. Otherwise, ODSP will not recognize the legitimacy of the trust. They'll see it as a protective vehicle. And that gift over provision is very important. So just something to put on your radar. If you are thinking about using a Henson trust in your will for a disabled child, make sure that there's another generation or another beneficiary in the event that the disabled person predeceases that other person. Another area that comes up just very quickly, where we see in families get a little bit messy on the estate litigation side, is when there's a second property, like a cottage. So if the cottage is left to 2 children or 3 children, and they are to manage or inherit that property equally, a lot of times what we see is a battle over who's taking care of it, who's putting more money into it. Now somebody wants out, they want their money. The other 2 can't afford to buy that one out, or one can't afford to buy the other one out. And then that person is resentful because they're being forced to sell the cottage to give half the assets or half the proceeds to the person who wants out. This is a very messy area and again, a growing area in estate litigation. And a lot of estate lawyers that I have worked with have said, do not leave the cottage to 2 or more kids. You leave the cottage to 1, and then there's an estate equalization, either by, if the cottage is worth $500,000, then child number 2 gets $500,000 cash from the estate, and the rest is divided equally. These are the kinds of things that you do. And then of course you have to have that discussion with the children, who wants the cottage and who wants the cash, because, or some other equalization of car collection or something to that effect, to make things even and fair. But in the interest of avoiding that litigation process, it's often recommended by estate lawyers that you don't leave a second property to 2 kids. So I've talked a bit about this. This example is that John and Mary relies on beneficiary designations on their investments, such as a beneficiary for Ethan and Joseph. So if John and Mary were using segregated funds as part of their investments, they can declare exactly what percentage of each of the assets in those funds goes to each child and how, which is great. Also, segregated funds do allow for the estate the funds to bypass the estate, so no estate tax is paid on that money. And that's a pretty good way to go. So when we talk about beneficiary designation, and of course on life insurance policies, same sort of thing. And again, this is a great area where we see people equalizing the estate if somebody gets a cottage or somebody gets a car collection or something happens in that regard, then assets come from segregated funds or life insurance to make it even and fair. So power of attorney, I think a lot of people understand what this is. There are two types of powers, or two key powers of attorney. One is for personal care and the other is for personal property. A power of attorney gives the person clear direction on what you want done with your assets if you become disabled yourself or are deemed incapable in the eyes of the law, how your well-being is to be managed and how your assets are to be managed. These can be done in a couple of different ways. It can be a general or continuing power of attorney, which gives that person authority to act while you are alive and capable. That's part of it. Or springing, which is when, if there's an accident or something that renders a person incapable, that then would trigger the powers of attorney. These documents are very important and things to be very careful with, because in the event of a general or continuing power of attorney, if the person that you're giving that authority to is alive, they can act on your behalf right away, whether you want them to or not, which is why we generally, again, say if you're going to be using a general power of attorney, that document stays with the lawyer or with the financial planner or somewhere that is out of the hands of the person that is going to be given that power, with obviously with specifics as to when that power should be granted. So you want to be careful in these areas, and springing can come with issues too, as to debate around most recent and these sorts of things. So you want to be consulting carefully with a lawyer on these documents, but they're absolutely essential. They're a key component to risk management, because the last thing you want to do is be rendered incapable and have the province of Ontario decide what happens with your assets and your health while you're alive. And from the personal care perspective, if somebody does not wish to be resuscitated or not kept on life support beyond a certain point, this is where you would make those intentions clear, right? So you would then grant the person the power to, quote unquote, pull the plug. And that's a horrible way of saying it, but to tell the medical people that your wishes are no code or do not resuscitate or do not keep on life support. Good thing we're doing this on a dreary day, because it's such a morbid topic. I do apologize for that. It is such a key area of estate planning, but it's not a pleasant one. I will say that, but it is important. So a letter of wishes. This is a document that often accompanies a will. And it's a very good one, and we are recommending it more and more these days because, again, as I said, we're seeing a rise in estate litigation based on ambiguity in the will or the limits of what the will can say. And I'll give you a good example about that, which is in the case of our family that we've been using illustratively along the way here. If John and Mary live, I'll jump to the next slide just for visual. If John and Mary were to leave money to Joseph to aid with the support of Ethan, but the will would say that the money goes to Joseph, but it doesn't say what Joseph is to do with the money. In fact, a will cannot say what Joseph is to do with the money. However, a letter of wishes can. So the letter of wishes accompanies the will saying, I would like to leave this money to Joseph. Joseph is to use this money for Ethan's well-being. And that's one way of managing the money, of course, with a deep trust for Joseph that he's not going to abscond with the money himself. But usually that's fairly safe bet in families where everyone is getting along. Certainly that's the way it goes. So this letter of wishes is important because, again, I think you can sort of really outline what your intentions are for monies that you leave behind. And as I mentioned earlier, in some of the beneficiary designations and conflicting rulings and all of these sorts of things, a signed letter of wishes will really clear that up. And again, in the case of two executors or anything like that, then you have this letter of wishes, which goes beyond the scope of a will to really define what your intentions are, and whether it's to be put into a trust, and whether it's to be distributed to all heirs, or whether it's to be distributed to specific heirs for the benefit of a different family member. As I mentioned, that is a key component, and I highly recommend doing a letter of wishes with it. And it's something you can write out yourself. Again, I would get it notarized and have it kept and stored with the will. So that pretty much concludes this high level approach to estate planning. I hope I managed to get through that in some semblance of reasonable form and clarity. And if I didn't, I apologize, but I'm happy to field any questions if anybody would like to ask specifics.
Hi, Lumina. Do we have any questions in the comment box?
Not that I see right now, Ron, but if anyone has a question, you guys can unmute yourself and pose a question. You can raise your hand or just type the question in the chat box, and we will be able to respond. While everyone else is thinking of a question, I just wanted to ask Daniel. Oh, we have two people who raised hands. So Sinan, you go first. And I think I just got too excited and I raised my own hand. So Sinan, you're the first person to raise hands.
Hi, how are you doing? Thanks for the presentation, Daniel. The question I had is, we have a will that's set up with willful.co, you know, the online will management company.
Yep.
What are your thoughts about willful.ca, especially with a disability? What things we should watch out for? And the second comment, second question or second part to the question is, with willful.co, how do we ensure that we have something like a letter of wishes?
That's a great question. I'm familiar with it to the extent that I've heard of it, and I know a few people who have used it. I don't know if you are able to store a copy of any additional documents through that tool. I am often, in the cases of a person with or a family member with a disability, I'm a little bit tenuous when it comes to sort of DIY or ad hoc approaches, because there are so many specifics in this area that something could get missed. In fact, I'm even reluctant to use just any lawyer in this area. I want them to have a very deep understanding of the world of disability and finance and how that pertains to finance and law. So I'm a little bit reluctant to suggest that that's the best path forward. I can't say it's bad. I don't have enough experience with it to be perfectly candid. I would just maybe consider if you can't attach something to it on that form, you may want to look to have a copy of it stored, again, either with your financial planner or with a lawyer that does work for the family in other regards, just that it's somewhere on the record. For example, my firm, we're using a software suite called Side Drawer, which allows all family members to have access to the documents, but they can't see them unless there are triggering events. And that's kind of a great way to deal with it. Lots of firms and other financial companies are using something similar, I'm sure. But yeah, that way you can have the letter of wishes there, the powers of attorney and the will, and all of those things are kept from the other family members until they're triggered. So that's something that you might want to consider, unless you can attach a document to it on that web portal. Does that answer your question?
Yes, thank you so much.
Pleasure.
There's a question in the chat box. What is the difference between CODIC?
A codicil?
Yeah, codicil and
And
letter of wishes.
that's a good question. You know, again, I wish I had Percy here to field that one. To be perfectly honest, I don't know. I don't know the answer to that one. So I could look it up for you if you want to schedule time to chat after, or perhaps I can get your contact information and reply if you're comfortable with that. You can message me directly. I'll put my email up in the chat.
I don't know if anyone else has a question. I had a very quick question, just because I don't think a lot of people have yet, been able to withdraw from RDSPs and stuff like that. So when we are thinking about drafting a will as someone who has an RDSP, do you have any advice on that front? And, in case we pass away and there's still some money left in our RDSPs.
Yeah, absolutely. So RDSPs as a registered account should have a secondary beneficiary declaration option on them. I know that the applications are a little bit different than your standard registered account, and the best way to manage it is to use the will to direct any residue in the RDSP is paid out. Now, there are rollover rules for RDSPs if there's another family member who is disabled. If there isn't that, typically what has to happen is the RDSP is collapsed, and the rules around the collapse of the RDSP largely are focused on there. So there are two different types of plan. There's the PGAP RDSP and then the non-PGAP, which just means PGAP means predominantly government funded. The government has put in more assets than the individual themselves has. So in cases like that, typically, again, if we don't have the 10-year vesting window isn't cleared, the government will take back what they call the assistance holdback amount. And that money will be reclaimed. And it's kind of obvious as to why, because that money was given by the Canadian taxpayer for the benefit of the disabled person. If the disabled person passes on, they don't need that money and it shouldn't go to somebody else. So it's just kind of the general rules there. The government will take back what they call the AHA, or the assistance holdback amount, or the reclaim all of the grants that they've put in, or the bonds as well. Now, if the 10-year vesting window has passed, meaning no contributions from for the last 10 years, then all of the money in there is deemed to be vested, meaning it is the benefit, it's the RDSP beneficiaries, they're entitled to it. So if at that point they pass on, then that can become part of their estate. Now, again, subject to the withdrawal rules, RDSPs are not cut and dry with how you take money out of them. So the withdrawal rules, again, depending on whether it's PGAP or non-PGAP and these sorts of things, will apply to collapsing the account as well. And the management of the estate may get around that if the estate can straddle a calendar year. So I'm sorry, that's a really circuitous, long-winded way of saying it, but the RDSP is a tricky account to manage on the redemption side. Pretty easy to put money into, hard to get money out of without complications. So, and again, in the event of a death, those withdrawal rules will apply.
Thank you.
Now, Wade, I think Wade's got his hand up.
Yes, going back to the business of a cottage.
Yep.
Is it not better to transfer ownership before you die, as opposed to leaving it in a will to be transferred?
You can do that, yes. And typically what that'll do is it will reduce the estate tax. Technically at that point, it is a deemed disposition. So if it's a secondary property for you, you would owe the capital gains at that time. Right. And the reason why some people don't want to do that is because they want their estate to pay the capital gains. So that's the one sort of tricky thing to worry about. But if you have the means to pay the capital gains and you want to do it all above board, then the day you transfer it to the child or children, you'll pay the bill.
Yeah. Okay. Thank you.
Okay.
Any other questions, comments?
No, I also, Daniel, I think your email just was sent to me via direct message. Did you want it to go to everyone?
I did send it just directly. Yeah, you're right.
Yeah, so if you could just resend that.
To everyone. There we go. See.
And I don't see anyone with a raised hand, and I don't see any questions in the chat window. So we'll just wait for Daniel to send his email to everyone. And if no one else has questions, then I think we can wrap up the event.
Yep, I was just going to mention, for those of you who are not quick writers like myself, if you do require Daniel's email address, please contact me or Lubna, and we will get that out to you.
Yeah, for sure. And you can find us too on hudsonwealth.ca. You can go there. All our email addresses are published up there. Well, the three partners anyway. We do manage all clients, even for sub-advisors who do some work with clients, but you can contact any one of us through that. And we're happy to book one-on-one consultations if somebody's looking to get, some advice. This is obviously, it's a private area of finance, so I can understand if people have questions and they don't want to ask them in this milieu. By all means, do schedule some time to chat. We're happy to support SCIO and its members. So any time there.
Daniel, what would be your catchment area?
We service all of Ontario.
Okay.
At present, we're actually preparing to expand out west. But right now, Hudson Wealth services all of Ontario.
Great, thank you.
My pleasure. Yeah,
Well,
it's the nature of being a specialist in disability. There aren't a lot of us out there, so it's the only other. I don't think there are any other firms. There's one or individual practitioners here and there who've got a disabled child who've learned a lot along the way. I think they do some work, but as far as a firm that focuses on disability finance, I believe we're the only one in Canada.
Well, it is a much needed service, so thank you.
Indeed. Yeah,
Thank you so much.
It's funny. I started my practice in this area after I left. I was in the world of structured settlements prior, and I just felt that structured settlements were not doing enough. So I started my practice in this area, and I very quickly became overwhelmed with the amount of research that was required. So I kind of pulled back and went into research mode for quite some time. I still learn something every time I have to go back to the drawing board and research on a file. But yeah, it was a long, big, steep learning curve. And that's why both my partners said the same thing. They were like, wow, this is a lot of digging to understand this. And it's a complicated area of finance for all the reasons we discussed today. Estate is one of the most complicated areas.
Well, like I said, it's a much needed service because there's a lot of us, living with physical disabilities and disabilities in general that really require that type of expertise. So it's a good thing we've got, people like yourself and Percy out there being able to represent us.
Happy to help.
Good. Well, seeing that there's no other questions, I just want to remind you that, if you have any topic ideas, please get in touch with Spinal Cord Injury Ontario, or if you require any of our service like peer support or regional services, again, go to our website, check it out, and you can self-refer if you'd like, and also check out our marketplace tab that we have there as well. So I want to thank you all today for joining in this session. Like I said, it's a great session, and I'm just so glad that we are able to tackle this. So I would like to thank our sponsors today. The financial series sponsor is Meridian Credit Union. Our session sponsor is Hudson Wealth. Our community sponsor is Learners Limited Liability Partnership. And I want to thank you because without you, these sessions are not possible. So thank you very much. And I know it is a dreary day, but please try to enjoy your Monday, and I hope to see you next month. Thank you very much and have a great day.
Thanks, everybody.